If it pleases the court, David Castleman, also for respondent, Aaron Leider, actually. It seems my job to correct the pronunciation of his name. The city claims that prosecutors have had discretion and retained discretion to prosecute this illegal criminal behavior. And I think their argument protests too much and proves too much, because the entire point is this is behavior that's lasted for truly decades. It's not unknown, and there's been no remedy for this criminal conduct. And it has been brought to the attention of the City Council. City Council's members have been voted out. District attorneys have left office, but the criminal conduct continues. That's exactly what 526A was enacted for.
Before you proceed, can you break down when you say criminal conduct? I know it's alleged criminal conduct, and I realize, as has been discussed here from the bench, the prosecutor's obligation is to pursue a cause of action against a person when they are satisfied they can prove the case beyond a reasonable doubt. So I really don't know exactly why the DA hasn't brought this action, but I'm wondering where I've heard repetitively that it seems like a conclusion that we all agree this is criminal conduct. However, I suspect the other side, Los Angeles County, the zoo doesn't think that. So when you say criminal conduct, what do you mean exactly?
Well, first of all, this case is unlike any other 526A case I'm aware of. It went through trial. This case was tested after a civil trial, but the court...
The criminal law is enforced beyond a reasonable doubt.
That is correct.
All kinds of procedural safeguards.
Correct, and I think that highlights the nature of this case versus a prosecution under the criminal law. We do believe it's criminal. We do believe the evidence has shown that, but it is true it wasn't a criminal prosecution. I think this is what makes this case very much parallel to the Stop Youth Addiction case, which I believe is controlling here, the majority opinion written by Justice Werdiger. And it is another civil case. It's statutorily authorized by law, borrowing the penal codes, and it was made very clear in that case where the issue was unlawfulness under the unfair competition laws versus illegality here, a distinction I'm not prepared to parse. But neither one usurped prosecutorial discretion. The fact that they retain discretion even now highlights the point. It is the fact that there has been no remedy for the wrong, and whether it rises to the level of criminal misconduct in a criminal court isn't the issue.
Well, it has to be criminal conduct.
Well, I'm saying if there were to be a criminal prosecution, I'm pretty comfortable with the outcome, but I'm not the court and I can't decide.
It's terrific that you're comfortable with it, but that doesn't really prove much.
No, but it did prove something in trial when we raised the issues, and we were told by the court that we were required to prove it by a penal code standard. That's what Leider 1 stands for. We didn't ask to prove the penal code level requirements of illegality, and we were told that is the standard by which we must carry our burden, and that's what Stop Youth Addiction said. You're not enforcing the penal code. There you were enforcing the unfair competition law. Here we're enforcing 526A. What we're doing is seeking a civil injunction, not a criminal penalty. And all the references to criminal penalties, I think, are improper.
I guess the sticking point is that it's almost like a little theoretical issue in the middle there, which is conduct criminal under the penal code if it's not proven to a sufficiently high degree? In other words, you seem to be interpreting the penal code as setting forth certain prohibited behavior, which it does, of course.
Right.
But our background understanding is that because it is penal in nature, yes, we don't attach the label of illegality or criminality to that conduct unless it's proven beyond a reasonable doubt.
That's fair, but I should point out for purposes of 526A, this is no different than an Evidence Code 669 negligence per se case, where the court says you can prove your negligence claim by proving that there was a violation of the criminal law. And it's the same as 17-2.
There's a specific exception written into the code for just that procedure, right?
Yes, and the point, I think, though, is that...
And I'm sorry to interrupt you, but that exception has been part of the law for going on 200 years.
Which law are you referring to now?
The exception for nuisance?
No, I'm talking about negligence per se cases. In a civil court, a plaintiff comes in and says, I was injured, I tripped over something that violated the criminal law because it was too high, too low, the defendant violated this standard of criminal law. And those are daily civil burden of proof issues based on this standard provided by the penal code. It's not proving a crime. It is the measure by which the civil claim is allowed to proceed.
But the distinction here is that the hook on which you choose to go forward is the commission of a crime. It has to be criminal conduct.
Well, I think it has to be an illegal expenditure. And it is
It's an illegal expenditure only if the underlying conduct for which the expenditure is made is criminal.
No, it has to satisfy the standard of 526A, just like Stop Youth Addiction did not involve proof that there was a violation of Penal Code 308. You sell cigarettes to minors and you're not automatically guilty of a crime, but that was the precise allegation there. It was unlawful because they violated Penal Code 308. They were allowed, and this court is very clear in saying that what we're talking about here is not an attempt to directly enforce the penal code. It's a civil action. And I think what's important also about the earlier discussion about this comparison between 3369 and 526A, and it isn't 3369 impliedly overruling 526A, which is what the city is claiming. If you're talking about implied repeal, 3369 comes along and adds a broad exception, and the position of the city is that somehow overrules and repeals 526A. That's unthinkable. And Stop Youth Addiction looked at the same issue and said the law shuns implied repeals unless the two statutes cannot in any way be reconciled.
Are there other examples? I'm not sure your negligence example is the best analogy, just because in that situation, the court is applying common law concept negligence, and it is looking to lots of places for understandings of how you measure conduct. Criminal law is certainly one available body of law, but courts look all over the place for what are reasonable precautions to take under certain circumstances. So that is not fundamentally about proving a criminal violation. That's courts resort to bodies of law for guidance as to what reasonable standards of conduct are in society. Your Stop Youth Addiction example seems more pertinent, and I'm wondering if you have more examples like that where the general term unlawful or illegal appears, most relevant for you in a statute, and it encompasses this kind of broad understanding without requirement of proof beyond a reasonable doubt if it's something that's in the penal code. Is that something that occurs a lot in the law?
It does not occur a lot, and the reason is because you're talking about statutory authorization here, a statute that carries this word unlawful or this word illegality. And the reason you can't, by Mendes, ALDF versus Mendes, and by the way, in our brief, we incorrectly indicated counsel was on the ALDF Cal Expo case. It was actually ALDF versus Mendes case, so my mistake. But in the Mendes case, they make the point very clear. You cannot just directly sue to enforce the penal code, and we get that. And that's not what's going on here. And again, I think that Stop Youth Addiction is the closest parallel. But back to the negligence per se thing, I don't want to give it up completely, because it goes further than just saying, look at the penal code. It talks about the class of defendants, the behavior, the people to be protected. And you go down this whole ladder of issues that are tied to the question, have you met the requisite element or the burden of proof in this case? And they're looking to a penal code to satisfy that. And the same thing is true in Stop Youth Addiction and in this case. You're not trying to prove that they committed a crime and punish anybody. It's just not the issue. It's a civil case, purely civil. And it is borrowing, in the words of Stop Youth Addiction, a penal code in order to allow that to go forward. And unlike Stop Youth Addiction, which talked a lot about this allegation that the lawyers were lining up and doing illegal things to try and make money, trust me, there's no line of lawyers lining up to prosecute cases to 9 years fighting City Hall to get an injunction. That's just not happening. And so the real reality is that this case is filling a very important void in the law. And I would go back to the distinction that the court has asked questions about moving the language out of 3369, 17202 would be redundant if otherwise provided by law was supposed to somehow refer back to that unfair competition language that was moved. They created two different things. 17202 says notwithstanding 3369, and then the main statute, 3369, says nuisance or as otherwise provided by law. Clearly broader, clearly not referring to the language that was moved.
I think the claim is not that it's specifically limited to just unfair competition, because clearly it's not, but it's that the manner in which the provision of law must state the exception is exemplified by the clarity of
Right.
the Business and Professions Code provision. That's the argument.
I understand it, and I'm saying the reverse of that is what they're really arguing. They're saying that 3369 literally obliterates 526A. And that's just not written anywhere. By adding or otherwise provided by law, somehow that made this case statutorily expressly authorized, not permissible. And I think that is a far stronger charge. And I think it's important to note that what we're talking about is litigation under 526A designed in this case to protect elephants versus a rule that they're looking for to say we should allow criminal or illegal, depending on how you parse it, conduct to keep going, understanding that prosecutors aren't going to touch it.
Is it surprising to you that there doesn't seem to be any case law?
On which issue?
On taxpayer action to enforce the criminal law?
It does. And part of the
Why is
reason...
that? I mean, if this is such an important gap in the law, wouldn't we have seen this?
I think what we're seeing is largely coming from the ACLU, which is why they are here, because they're using it in different contexts, and counsel's pointing to the penal codes, which have this same relationship, civil action using a penal code. But I think that what's important is that the statute says what it says. The statute's overarching purpose is clear. It's intended to be broad. It's supposed to be liberally construed. Candidly, I don't see the law liberally construing it. I think the case history has been far from that. But that's supposed to be how it's treated. And here, the argument is made that even though it's illegal, even though you've been through trial and you've proved you met this standard on a civil basis, somehow this case shouldn't be allowed to proceed because there's a common law doctrine that doesn't expressly say you can't do this. And I find that much more strange than the fact that there weren't lawyers who would step up pro bono to take on cases like this. I also think that we haven't distinguished the fact that Lim, again, was a government prosecution. And the point of Lim is to protect citizens against the government. It wasn't designed as this case is developed to protect government against citizens who are acting under a statutory authorization. In fact, both Lim and Schur all say, absent legislative enactments, you can't do this. Well, here you have a legislative enactment. And again, in doing so, it doesn't violate the problem in Lim about having prosecutorial discretion or the burdens of proof because it's purely civil. I think since nothing's been said on the second question, I should mention the law of the case issue. And procedurally, this case came up through a summary judgment. Leider 1 analyzed it and said that you can have a justiciable controversy if you prove under 526A that the penal codes were violated. Then the case comes back down to trial and a demurrer was filed. And very much like the U versus Signet case, the court, even the trial court, looked at it and said, wait a minute, the Court of Appeals already said that there's a basis not only to proceed, but that there's a triable issue of fact on that. Therefore, the court has already decided that you stated a cause of action. And then, of course, in Leider 2, the court said as much, viewing the law of the case issue. And that is really a recognition that what we're talking about here is just a refinement of the old arguments that were made. And it's not like the estate of Horman case where they're effectively raising an affirmative defense, which wouldn't come up under the whether you stated a cause of action test for a normal demurrer. And of course, that leaves open the manifest misapplication and substantial injustice issues. And We believe, of course, that the ALDF Cal Expo case was wrongly decided. It was not at all entitled to rely on the Mendes case because it wasn't a prosecution of a 526A case. There were no public defendants. And ADLF turned on the mistaken belief, as did the following case. The LDF turned on the mistaken belief that SPCAs could somehow step in and magically make this all right. And again, we have decades of proof that the SPCAs, which are not empowered to do it, would love to be able to do it, but cannot stop this kind of misuse. And the record is replete with the kind of evidence that Your Honor asked about, which would make it a crime. I'm not going to belabor that, but there's a lot of that kind of factual grist in the mill that has prompted a lot of people to try. And this case was filed ultimately because literally no prosecutor, no one else stepped up. And so I think the bottom line from our standpoint is that there are no criminal penalties possible here. There is only the meaning of 526A and the Stop Youth Addiction case, which I think parallels and supports it. And without 526A standing, it's pretty clear that this kind of public animal cruelty will go unchecked.